Thank you very much. First of all, let me thank you to the organizers of this wonderful conference in the beautiful country of Israel. Let me say just a few words about me. I come from the Czech Republic, from the law faculty of Charles University in Prague, where I'm a member of the Department of Civil Law and also of the Center for Medical Law. And this presentation, which I would like to share with you, is something which I put together with my colleague Petr Šustek, who is also a member of the Department of Civil Law and Center for Medical Law. And it focuses on advanced directives and mental health. And I will take it from the perspective of Czech law, although I think that the problems and issues that we are faced with are quite similar in our country, like in other countries throughout the world. First of all, let me give just a brief introduction about our system. The relationship between healthcare provider and patient is based on civil or private law. It's typically based on a contract, and we even have a special specific contractual type in the civil code. The civil code is the fundamental statute of civil law, and it also contains regulation about some typical contractual types or typical contracts which you may enter into, such as purchase agreement, mandate agreement, and also agreement for care for health. Interference with personal integrity is again something regulated primarily by civil law, and it's based on a legal reason. You have to have a legal justification to interfere with someone's personal integrity, and typically it's the free and informed consent of the person. There is also care provided outside of a contract, such as in case of emergency treatment or obligatory treatment of contagious diseases, some vaccinations, etc. Obviously, and it's I think the same for all countries in the world, there are conflicting interests in play. First of all, we want to protect the health, but we also want to respect the individual wishes and dignity of the concerned person. And this is legally expressed as protection of integrity and principle of informed consent. And this is true even in case when the patient has no individual wishes or has not expressed any individual wishes. She is still not a mere object of care. Dignity of a human being dictates that she has to be protected even in such case. Now, there may be that the mental capacity of the person concerned is impaired in some way. The patient may not be able to fully exercise the decision-making autonomy. This may be a short-term or long-term problem, and this may be a complete or partial inability to make the decision for themselves. Now, how does the law approach this situation? Well, if the person cannot decide for herself, then the law usually turns to a substitute decision maker. It may be close relatives, it may be legal guardian, it may be the courts, it may be physicians. And the law quite often employs more than one category of substitute decision makers, or maybe even employs all of them in different scenarios. For example, the close relatives, such as close family members, kids, spouses, parents, etc. They are the ones that we would normally expect to decide for someone who is unable to decide for him or herself. But also, sometimes the substitute decision maker is the physician, because if you have a case of urgency, if someone is brought into a hospital unconscious after a traffic accident and there is no one from the family present in the hospital, then the substitute decision maker is the physician, because there's nobody else to make the call on behalf of the patient. So we can see that the law may work with all these categories, and these categories may overlap. Because in case of treatment, for example, in a hospital, there may be relatives present, the physicians may have their own opinions, sometimes they agree with each other, sometimes they don't, and there may be conflict either between the categories. For example, the physicians may have one opinion and the relatives may have another, but there can be also a conflict in the same category of substitute decision maker. For example, imagine an old man whose wife already died, and he has Alzheimer's disease, for example, and he has two adult daughters. Both of them are in the same relation to the patient. They are both potentially the decision maker on behalf of their dad, but they may have different views. For example, one of them would approve rescue treatment of her father, the other one wouldn't. So there may be conflict even inside those categories. Now, one possible approach we may take is to employ the advanced directives, because perhaps the patient could help us in this situation by giving the directive him or herself. The question is whether such directive should take precedence over the opinion or decision of the substitute decision maker. Well, the problem may be that the directive is not clear enough, because often the situation is not about a simple yes or no. For example, if I should decide whether I agree with donation of my organs after I'm dead for transplantation purposes, that's, in a way, it's a simple decision. I know that one day I will be dead, I know what my organs are, and I know what transplantation is. So I can decide, okay, you can have it, you cannot have it. But it's much more difficult to imagine all possible situations or all possible scenarios to give a sufficiently clear and specific advanced directive as regards healthcare in general. And another problem is, what if there is new information? The patient's directive made in advance may not correspond optimally to new information which was unavailable at the time when the patient gave the directive. And that's an obvious problem. Now, what is the position of Czech law? Actually, we are trying to follow the Council of Europe 1997 Convention on Biomedicine and its Article 9, which says that the previously expressed wishes relating to a medical intervention by a patient who is not, at the time of the intervention, in a state to express his or her wishes shall be taken into account. That means that there should be respect for advanced directives, but without making them absolutely binding. And the national law, which tries to implement the Convention on Biomedicine into domestic law, says something quite similar. Now, there is an advantage of this approach, that it allows to respect the patient's wishes, and at the same time it allows to take into account new information. But it also has problematic implications. Now, would new information have been sufficiently material for the patient? And who will decide it and how? The problem is that the decision maker, for example a court, is risking that they will use their own view as if it was the view of the patient. In other words, they will project themselves into the patient's situation and ask, what would I do or what would I think in such a situation? But that doesn't mean that that's the same thing which the patient would decide if it was up to him or her. Another problem, if we take this approach, is can a physician rely on the advanced directive against the opinion of close relatives who would otherwise, being the close relatives, be entitled to make the decision on behalf of the patient? Or is the directive only binding on the decision maker, that is, on the close relative? Now, the difference I'm trying to make is that if the physician could rely on the advanced directive against the opinion of the family, it would mean that their legal act, their consent or denial of consent, would be invalidated by the directive. But otherwise, they would remain entitled to decide on behalf of the patient, but could, for example, be sued by other other relatives for breach of personality rights, or, for example, the other relatives could ask for appointment of a legal guardian of the patient, etc. So there is also an important question what binding means. If it's binding, overriding the legal will or legal act of the decision maker, or if it only binds the decision maker and pushes him or her to take a particular approach. Another related problem is termination of life support. It is a connected issue because if we have the cases of patients without sufficient mental capacity to decide on their own at the critical time about discontinuation of life-supporting treatment, that's again a situation when we have to ask whether there is an advanced directive or whether there is some substitute decision-making authority. And the question of precedence of advanced directives versus substitute decision-making may have decisive effect on the actual outcome of the case. Now, our civil code is unfortunately unclear as to the role of the court in case of life support termination. Given that it's quite a serious matter, it's perhaps a bit surprising, but that's actually the case. Obviously, if there was a dispute, there is no other guaranteed solution than going to a court for judicial proceedings. But the Civil Code only deals with approving treatment. The relevant section 101 only deals with approving treatment, and it doesn't say a word about discontinuing treatment. It actually reads, I will read the text of the section for you, if the integrity of a natural person incapable of judgment is to be interfered with by manner resulting in permanent, unavoidable and serious consequences, or by manner connected with serious risk for his life or health, the intervention may only be carried out with consent of a court. So it only speaks about carrying out an intervention but not terminating life support treatment. And the lack of clarity in civil code and in procedural law may, I think in this case, cause breach of principles of Article 2 of the European Convention on Human Rights as interpreted in Lambert and others against France, which is an ECHR case dealing with a similar situation which calls for clear legal rules in this type of cases. Coming to conclusions, I would like to emphasize perhaps just 2 points. First of them is that disputes among family members of the mentally impaired patient and between them and physicians should generally deserve, let's say, a therapeutic jurisprudence approach. That is an approach trying to reconcile and to bring them all aboard ideally to reach the same conclusion. It shouldn't be an antagonistic juridical approach, and this is something which we should work on. And the second point is that perhaps it might make sense to establish a commission for consulting or perhaps even improving serious medical interventions or discontinuation of life support to act as at least a help for the courts if they are the ones who should make the decision on behalf of the patient. We have some similar ethical commissions, or to some extent similar ethical commissions in cases of transplantations, sterilizations, sex reassignment therapies, etc. So I believe that the cases of serious medical interventions on mentally impaired patients or life support termination of mentally impaired patients should deserve the same attention. Thank you very much.